The material I present today reflects my current interest in what I, following authors such as Robert Hefner, call regimes of religious governance. How is religious plurality regulated and shaped by the state, and how does this regulation affect interreligious and intra-religious dynamics on the ground? By religious plurality, I refer to situations in which religious traditions and groups coexist in one place and time, showing various degrees of mutual tolerance and articulating a multitude of religious practices, conventions, and understandings. Religious pluralism, in contrast, which I won't really employ for the purpose of this presentation, but I just want to clarify how I see the difference. In contrast, denotes a particular attitude towards plurality that exceeds the mere acknowledgement of other religions and of diverse religious and non-religious viewpoints and related practices. It implies the acceptance of the validity of other religious understandings and hence the recognition of normative difference. So that's why I draw this distinction, and we'll talk mainly about religious plurality. By talking about regimes of religious governance, I want to combine an interest in the legal framework and judicial institutions with an attention to bureaucratic and political processes that together help account for inter-religious dynamics and power constellations. My perspective is informed by authors such as Bali and Lerner's interest in constitutional strategies aimed at dealing with potential conflicts over religious matters. And there is simultaneous call for attention to the diverse political processes and mechanisms that help account for the ultimate outcome of religious conflict constellations. I also want to move beyond the focus prominent in current Africanist scholarship on lived religious diversity and on everyday forms of accommodation, a focus that, in my view, risks downplaying the potentially divisive effects of state regulation of religious coexistence. So even if individual believers might favor pragmatic accommodation of religious difference and engage in mutual borrowing of religious conventions, something that is very much stressed by this strand of African scholarship, unequal treatment of different religious constituencies by the state might foster greater divisiveness among them and encourage them to stress irreconcilable difference. Only by combining these different levels of analysis might we come up with a systematic account of modes of religious coexistence in Africa and elsewhere. My specific perspective, to which Ulrike already alluded, is how does the situation look like from the point of view of Muslims as a religious minority in Uganda? Part of my project is the empirical investigation of the workings of what I call intermediary institutions or actors that act as points of articulation between state institutions, policies, and religious communities, such as the Hadith courts or the district Hadith office. But so far, because of the Corona situation and some other factors which I might mention during the discussion, I was not able to collect the data on the actual workings of those intermediary institutions and on practices, decisions, and negotiations by actors. So in preparing or in thinking about how to frame today's presentation, I decided in the end to come up with a kind of makeshift solution. So in the first part of my presentation today, and I see this very much in the sort of context of trying to sort of foster a conversation here within the context of this cluster, I will sketch out the main lines of debate with regard to Uganda that address questions of legal pluralism in Uganda. And in the second part of my presentation, I then want to turn to the question of how religion and relations between religious communities are currently regulated, and also how we might study them. Here I want to consider not just the legal framework and institutions, but the formal and informal political dynamics, which in my view play an important role in understanding the situation of Muslims in Uganda and their possibilities to mold their relations to Christians as the country's religious majority. So for those of you who are not too familiar with Uganda, let me start with some information about the political history of Uganda. Uganda formed part of the British colonial empire as a protectorate since 1894. The country gained independence in 1962, and since then its political history has been marked by protracted periods of civil war in different regions. In 1986, the current president, Museveni, and his NRM government gained power after fighting about the Bush War against the governments of Idi Amin and then Milton Obote. Uganda has had several constitutions. The current one was promulgated in 1995 as the result of a highly publicized, allegedly participatory process of constitution drafting. Some information on religious demographics in Africa, so that you know the context. About 85% of the population is Christian, divided among Roman Catholics, Anglicans, Pentecostals, and Seventh-day Adventists, Baptists, Orthodox, and Orthodox Christians, 12 to 15% Muslims and other religious groups, which form less than 5%, which include Hindus, Jews, Baha'i, and adherents of so-called traditional religions. The different religious groups need to be registered officially and are represented by umbrella organizations such as churches, the Ugandan Muslim Supreme Council, and also the Indian Association in Uganda. Uganda has no official state religion. However, with the exception of Idi Amin's regime, Christian identity and governmental and party politics have always closely intertwined in Uganda. In continuity with the British colonial administration in the first constitution of Uganda, the 1995 constitution recognized separate family laws for Christians, Muslims, Hindus, and customary marriage. No codified Islamic law exists in Uganda. It is merely stated that the regulation of Muslim marriage should be based on the rights and observances of the Muslim religious community. The 1995 constitution also provides for the establishment of Qadi courts as subordinate courts for Muslim family issues, yet with a few exceptions in central Uganda, which means southern Uganda, these courts have not been implemented. Individual Muslims tend to present their issues to the village imam, then to the local councillor or the district Qadi's office of the Uganda Muslim Supreme Council for arbitration. Yet most Muslims are even ignorant about the Qadi courts and present their Qadis, their cases to the family protection unit of the police and later to the civil courts. And with this sort of general information, I want to move to those different strands of debate with regard to Uganda in which notions of legal pluralism have played a role. So first of all, the phenomena that could be classified as instances of legal pluralism in Uganda are diverse, depending on the power constellations and conflict histories of the country's various regions. Legal pluralism refers to different forms and sources of law or norms and to varying problem constellations. Recent scholarly debate on legal pluralism in Uganda has centered on three main thematic fields, with mixed sometimes contrasting judgments about its beneficial or nefarious effects. The first thematic field is the regulation of access to land, which is of primary importance as land as the main source of subsistence in a country in which 70% of the population live off agricultural production, and where the growing commercialization and privatization of land in rural and urban areas has gone hand in hand with increased land grabbing by national and international investors. The situation is complicated by the diversity of land tenure systems and considerable regional variation in the degree to which they apply. So without going too much into detail about the 5 types of land tenure systems recognized in the 1995 Constitution, 75% of the Ugandan land is held under customary land tenure. In the 1998 Uganda's Land Act formally recognized the importance of customary institutions and regulations concerning land, stating that all disputes on land held under customary tenure should be resolved according to customary law, and that the customary authorities have the power to determine and mediate in those disputes. In Uganda, customary norms grant land ownership to men in their roles as the heads of the family, whereas married women and daughters enjoy secondary rights through their husbands or fathers. The Land Act also established local land tribunals and other local level institutions to deal with land disputes. But de facto, these institutions are only operational in some areas of Uganda. So legal pluralism in the area of land tenure has been treated along 2 main axes of reasoning. The first one, which I label institutional plurality as a problem, is represented by scholars who assess the effects of the decentralization of land administration based on the 1998 Land Act. They argue that the formal recognition and institutional support of legal plurality led to institutional proliferation that, quote, simply added new institutions to existing authorities and regulations, end of quote, resulting in greater confusion, indeterminacy, and competition between representatives of the state and customary land institutions, which ultimately undermines their credibility and effectiveness as they interlock with local level politics. So the tenor here of this line of argument is institutional plurality is a problem that, however, is not necessarily resolved by expanding the reach of state institutions. The second line of reasoning, which I call, for better or worse, legal incongruency as a problem, is pushed by national and international NGOs and human rights activists. They maintain that customary authorities apply rules that disadvantage weaker groups of society, including women, particularly widows, less powerful families, and in the post-conflict settings of northern and northwest Uganda, orphan children. Here the argument is that the situation of legal pluralism runs counter to constitutionally embedded principles of gender equality and international human rights standards, with the implication that customary law and statutory law should be harmonized through a process of unification by codifying customary regulations to align them with constitutionally embedded and international human rights standards. So the tenor here is the risk of disadvantage should be resolved by subjecting customary regulations and institutions to state law and control. The 2 lines of reasoning I presented so far often combine with the argument that the practice of state law in Uganda is to a significant degree a problem of their ineffectiveness of the ineffectiveness of the state court system in sanctioning transgressions of its own laws, and that existing institutions operate in a vacuum and are not enforced by state institutions. So the common denominator of all those different arguments about the potentially negative effects of legal pluralism with respect to land tenure is that they favor that those arguments, this literature favors a state-orchestrated effort to formalize and streamline legal regulations and to subject their enactment to state oversight. A second debate framed as a matter of legal pluralism is the transitional justice versus criminal justice debate. I mentioned this debate only briefly because the issues at hand seem to me not always a matter of legal pluralism or of competing normative systems, such as competing understandings of justice, but rather, at least sometimes, of competing goals, which means achieving lasting peace versus achieving justice. So very quickly, just for your information, the transitional justice approach refers briefly to the judicial and non-judicial measures to promote reconciliation and enable reintegration of ex-combatants in the country's different regional post-conflict settings. And it sort of highlights traditional tools of arbitration, mediation, adjudication, restitution, and punishment. And much of this literature operates through a discursive contrast between the stress and punishment, retribution and revenge in so-called Western justice systems, represented in the case of Northern Uganda by the International Criminal Court, and on the other hand, allegedly traditional practices tilted towards restoration and social harmony. So as I said, I don't want to go further into this debate. I just wanted to mention it in passing. The third debate, framed as a matter of legal pluralism, refers to the controversial efforts to reform the marriage and divorce law. The debate addressed, among other issues, the question of whether a distinctive Muslim family law should be maintained or whether it should be aligned with constitutionally entrenched principles of gender equality and international human rights standards. Representatives of the Muslim Umbrella Organization mobilized the notion of legal pluralism in the name of a more equitable treatment of Muslims as a religious minority and its right to enforce its distinctive norms and morality with regard to inheritance, divorce, and polygamy. And hence, as a mechanism and symbol of withstanding Western corruption of authentic, so-called authentic cultural values and a hegemonic Christian morality. This framing of the debate shows many parallels to debates around family law reforms in other African countries. What seems to be more specific to the Ugandan case is the overarching political weight of Christian politicians and state officials who push a specifically born-again Christian agenda. Conservative Christians align with Muslim critics of the draft law. They equally maintain that aligning the regulations of divorce, marriage, and inheritance with international standards undermined so-called traditional Christian values. This means that the main divide in this case does not oppose Muslims to Christians, but that it runs through the government or within the government and state apparatus, opposing secularist-minded state officials and politicians to conservative Christian members of the government. Where some contentious issues such as the minimum marriage age were settled in the course of the law reform process, settling, for instance, the age at the minimum age at 18, the controversy came to center mostly on the still unsettled issue of polygamy, which in the Ugandan case means polygyny. In response to the strong opposition by Muslim groups, in 2008, the bill was split into two separate bills, the Marriage and Divorce Bill for non-Muslims and the Administration of Muslim Personal Law Bill for Muslims, which left polygyny to the principles of the Sharia to be determined by the Qadi's courts, without, however, defining such principles or providing any condition. So far, the bills have not been signed into law. Polygamous marriages thus remain recognized in Uganda. But the issue is far from settled. The special treatment of Muslims has generated considerable opposition on the part of women's rights activists and various NGOs that, supported rhetorically by international bodies such as the UN Human Rights Committee, maintain that the legal recognition and practice of polygamous marriages in Uganda violates women's and men's equality before the law. Interestingly, Muslim activists who lobbied against the domestic relations bill did not raise as an issue that the Qadi's courts, although formally recognized in the 1995 constitution as subordinate courts for Muslim family issues, have not been implemented, and that as a consequence, Islamic law, as they refer to otherwise, is not widely applied. So, just to sort of draw summarize some of the points I made so far, Muslim activists seek to maintain a situation of formal legal pluralism in which state legislation recognizes separate family laws for different religious groups. They are sided by conservative Christians in this effort. The main dividing line therefore runs within the Christian community and does not oppose Muslims to Christians. So taken together, three fields of debate suggest that a mix of what I call formal and informal legal pluralism is at work at the moment. Formal because some pluri-legal arrangements are formally integrated into a system condoned by the state, and are informal in the sense that many customary and religious regulations are still practiced at the local level, in particular in areas where those who impose and enforce them operate in a vacuum. So far, I've argued that pluri-legal arrangements in Uganda, while partly formalized, are limited in their workings and effectiveness for various domains of social and religious life. In what follows, I just want to give a few examples of how religion and interreligious relations are regulated beyond the legal sphere through administrative procedures and informal political practice. Two mechanisms of regulating religious activity seem to be particularly relevant in their indirect effects on relations between different religious groups. The first is the formal requirement for religious groups to register to obtain legal entity status, which depends on the group's classification as a religion rather than as a cult. The latter being defined as, quote, a system of religious worship, often with a charismatic leader, which indoctrinates members with unorthodox or extremist views, practices, or beliefs, end of quote. This definition leaves ample room for interpretation of what serves as the default version of an acceptable religion that can be easily managed and administered. And the contrast between a religious group and a cult thus involves a process of standardizing religion and the transformation of religious identity into an element of bureaucratic governance. The contrast is enforced through negative sanctions, such as arrestation and fines for groups that refuse, for religious reasons, for instance, to participate in government immunization drives. The second mechanism of direct administrative regulation is the formal requirement for faith-based organizations to register as not-for-profit companies with the Ugandan Registration Services Bureau and secure a 5 years operating license from the Ministry of Internal Affairs. This registration requirement is, at least potentially, of considerable import because of the key social role of faith-based organizations in Uganda, which provide various kinds of social services and healthcare provisions, very often with the financial and logistical input of international donors and religious organizations, and thereby might unfold considerable political influence, as illustrated, for instance, by the US-sponsored evangelical group, the activities of which resulted in the much publicized anti-gay legislation of 2009. Still, although no formal criteria exist that grant exemption from the operating license requirement, so far, larger religious groups such as Catholics, Anglicans, Orthodox, Seventh-day Adventist churches, and the Muslim Umbrella Organization have not been obliged to obtain an operating license. In all likelihood, the lenient attitude by the state administration has been motivated by the important financial input by international donors that many of these organizations facilitate. But as a result of this very leniency, Christian faith-based organizations, thanks to significant financial support from international donors and by politicians, have been able to greatly expand their influence at the expense of other faith-based organizations. The sphere of primary, secondary, and tertiary education is another important social field in which state administration exerts influence on religious groups and endorses standardized versions of acceptable religion, thereby affecting inter-religious relations by bolstering those who support the state-endorsed version of their religious tradition. The state has developed separate curricula for Christians and Muslims. Public primary and secondary schools may choose which, if any, religious studies to incorporate into their curriculum. However, they, as well as religiously funded schools, which are rather sort of cover a broad spectrum in Uganda, must adhere to the state-approved curriculum for each religion they choose to teach. This requirement in the standardized versions of the two world religions it promotes is particularly momentous in view of the important role that Christian and Muslim-funded schools continue to play in primary and secondary education. In addition to these mechanisms of direct intervention, there are other practices that, although less straightforward and openly visible, play an enormous role in affecting relations between Christians and Muslims and in fueling dynamics within each religious community. One is the privileged employment of Christians in the state administration. Another one consists in the informal clientelist ties that connect individual politicians and high-ranking officials to representatives of religious bodies and foster rivalries and factionalism within the Christian and the Muslim camp through special favors, protection, and public support. All these regulatory measures and strategies form part of a particular form of governance, which, half bureaucratic, half clientelist, is strongly geared towards containment and control of the political influence of religious interest groups through strategies of cooptation and subversion. One result of these regulatory efforts is a process of standardizing religion, a process informed by the rationale of rendering religious institutions, authorities, and actors legible and manageable by the state, while at the same time allowing the government to capitalize on the substantial funds that these groups generate through transnational networking. So, before before I conclude, I just want to mention briefly some effects on those regulatory mechanisms on local level inter and intra-religious dynamics. The implications of this management for those interactions on the ground is that local power constellations between and within religious communities in Uganda are highly unstable and precarious and vary considerably from one region to another. And a very, very important role is taken up by those intermediary institutions and actors. In the case of Muslims, it is evident that district-level structures of the Muslim umbrella organization and also elderly men associated with individual mosque communities play a lead role in ensuring religious conformity and deciding on the mode of religious coexistence by asserting, in some cases, clear-cut boundaries and non-tolerance of religious difference in certain domains of social life. They do so, however, under the radar of the local district administration. Thus, rather than interpreting their interventions as taking place outside of the realm of the state, they operate as brokers who create and maintain points of articulation between state officials and institutions and the internal dynamics of Muslim congregations. So in conclusion, I just want to suggest 3 lines of interpretation for our discussion, but they are very provisional, so please bear with me. The first one is that we can see countervailing tendencies toward, on the one hand, the recognition and institutional support of a plural legal system, and at least on paper, of decentralized institutions of judicial decision-making, and on the other hand, the streamlining of existing legal plurality under the influence of international organizations and trends. Secondly, the formal institutionalization of certain forms of legal plurality might contribute to mitigating interreligious conflict, but fuels new disagreements and insecurities that ultimately bolster the key ordering role of state institutions and officials, at least symbolically. And thirdly, what I've identified as half bureaucratic, half clientelist forms of religious governance fosters conflict dynamics and internal power differences within religious communities that ultimately help the government in maintaining the image of a central ordering force whose existence is of paramount importance to maintain stability and predictability. And with this, I will say thank you.